My name is Nick Emanuel. I'm an assistant clinical professor here at the law school. I've been on the faculty for just over 2 years now. I teach civil procedure. I also have taught torts and remedies. This article, the inspiration for it is very organic. It came out of an afternoon in my first year torts class here at Santa Clara, and my co-authors, Lauren and Gavin, were students in that class. And the subject matter we were covering that day was something called the public duty doctrine, which we discussed in the article. And it's this theory that law enforcement, police, owe a duty or an obligation or responsibility to the community or to the public at large, but not to any particular individual. And the implication of that is that if they do something to harm an individual, that person has no recourse under the law because, according to the public duty doctrine, the police officer has no obligation to any particular individual. So we were discussing that doctrine, that rule, the public duty doctrine. And I think it was Gavin raised his hand and said, Professor, that doesn't make a lot of sense. The idea that police officers owe a duty to the public, for sure. But why does it follow that then they don't owe a duty, an obligation to any particular individual who makes up that public? And I said, that's a great question, Gavin. And I don't have a great answer for you. It doesn't make a lot of sense to me either. And then I think, Lauren chimed in and said, yeah, I agree. I'm not, I don't think I agree with this rule. And they questioned that, which is what we really like our students to do. And we think that by changing these rules, that's going to have a couple of effects. It's going to, one, lead to greater accountability for law enforcement, which will allow for ultimately safer communities, and really will better the relationship between police officers and the communities they serve by leading to more trust.